Stay tuned for that. We got the thing covered down there. Right now, the court is done for the day. We did mention earlier that the jury members went home. The attorneys and court did have a chance to go through some of the questionnaires, the jury questionnaires, to help kind of sift through those that might be a problem for both sides and or the court, and 16 of the first 50 were excused. So we're looking at a big pool to get down to 16 ultimate jury members, 12 plus 4 alternates. So with me still is Christa Ramey, and I guess I have to say beforehand that Kirk Burkhalter, professor, he had to leave. Yeah, he had to go. Normally I like to give him a nice shiny apple and send him on his way, but he had to leave a little early today. So luckily Christa is still here with me. Christa, thank you so much for sticking around. What is your thought on this, the potential for a federal case? We know it generally is used as sort of a backstop, maybe a, hey, let's take another run at this case because it failed at the state level. Is there really a reason for it other than that? Do you see state, federal cases battling one another and then deferring to the feds, or is it really just a backup position?
No, it's a backup position. What you see happening is it just in case things go wrong. You mentioned the Rodney King case. It's exactly what happened there. You had, I believe, 2 of the police officers that were accused in the Rodney King case that were acquitted in state court, then later convicted under federal civil rights violations. The feds will defer to the states, and they won't concurrently prosecute because the sentences will overlap anyway. So it's something you see particularly in these high-profile cases where you see that get a lot of attention by the media, and rightly so, I think.
Yeah, I mean, it really is a way around the old, one bite at the apple rule. We know that's drummed into us from law school into practice, but this is really the same. You call it something different, it's really the same. It's the same facts. You got a different cause of action, therefore it avoids double jeopardy, and it has been used effectively in the past. Let me ask you this, because we did have a chance to talk to some community members there in Minneapolis. That's an overwhelmingly liberal area, and I contrast that with the Rodney King case, first tried in the Valley in Southern California, which is a conservative part of Southern California, very white. And here in Minneapolis, it is predominantly liberal. In fact, I hear they're trying to get rid of the mayor of Minneapolis because the mayor's not progressive enough. So how important is it when this community is the community from which this jury is going to be pulled?
Well, I think it should always be the community from which where the crime happened. I think that was the problem in the Rodney King case. The case got sent to Simi Valley, which is a suburb of the greater Los Angeles metro area, and it is not only very white and very conservative. A lot of cops and sheriffs live there, and so in that particular sense, that was a travesty. When you are arrested and charged with a crime against an individual that lives in your community, the community should be the one that addresses that crime. It should not be some other community that addresses it. So I think that it's important that whenever possible, that cases stay within the jurisdiction in which they originated rather than going outside, unless there is a situation where a defendant simply just cannot get a fair jury trial.
Yeah, the whole jury of his or her peers was kind of lost in that shuffle. It made absolutely no sense to move hopscotch over the valley, of San Fernando, then Simi Valley, to get this group. It was destined to fail, and it did. So let's hear from, we had a chance to listen to some of the folks who live in the Minneapolis area,